Good morning. The presumption which prevails in India about custody of the child in respect of Muslim personal laws are concerned that the male child above 7 years must be with the custody of the father. So that area of concept has been now somewhat varied descended with by the Bombay High Court judgment, wherein they have discussed about various personal area of Muslim law. So this ratio was 2000 AR 2025 Bombay 260, AR 2025 Bombay 260, Khalida Alice Sania Ismail Kodri versus Ismail Akampla Shah Kodri. Guardianship and Wards Act, Section 7 and 17. So they say that particular Section 7 and 17 says that Muslim, so far custody of child is concerned, personal law would come to operate. But however, the ratio says the after interacting with the child will be better with the custody of the mother rather than the father, and the child since refused to stay with the father, and the father did not show any evidence that he is more financial capacity than the mother, so the custody was granted to mother and visitation right was given to father. But when they filed a first appeal against the lower court order, there was some disobedience by the mother, not obeying the orders, interim custody. However, that was also ordered. Now the question, the important aspect about this Muslim personal law has been discussed at various paragraphs of the judgment. I would like to share with you. Number one, they say personal law, Section 6 and 17 says Muslim law of India, guardianship and custody of minor under personal law. That is at paragraph 2. Father is the natural guardian and entitled to custody after 7 years. Then the question says parties are Muslim, they are governed by uncodified Muslim law. That was they say. However, the section says 17 of the Guardians of Wards Act, in appointing or declaring guardian of a minor, court shall, subject to provision of this section, be guided by what consistently with the law to which the minor is subject appears in the circumstances to be welfare of the minor. So this was there. Then question arises. In conjoint reading of Section 6 and Section 17(2) of the Guardianship and Wards Act, it is obligatory to consider personal law applicable to the minor in the matter of guardianship. Then say that Dr. Tahir Muhammad book, Muslim Law of India. So Muslim Law of India deals with children and parents, minority and guardianship. There are two classifications of guardianship subject. Number one, that vilayat-e-tarbiyat, that is called physical custody, and upbringing is ijanat. So the word ijanat and vilayat-e-tarbiyat has been differently discussed in this judgment. They say Walia Tabiyat is also popularly known as Izanat, but there is so far the sense of Izanat was not available in English dictionary. Waliyati is in English guardianship of the person. So two things are there. The concept of Izanat and Vilayat-e-Naf are distinct. This is at paragraph 18. Physical custody day-to-day of bringing up is the Izanat. All other aspects, then Izanat would fall in Vilayat-e-Naf. This is what they have discussed deeply about Izanat and this Vilayati now. So after discussing this, that was they say at paragraph 28, uh, for the purpose of Izana, Muslim law divides duration of minority in respect of every male minor in two stages. Marahil. Limit of stage are different from school to school. Following chart shows the stages under the summer school. The school stage was given, but we are simply following Anifila majority of the Indian population. So many judgments were referred, but this judgment is most important. This is what Gayatri Bajaj Jitan Balla, wherein the fathers taking the custody forcibly, and these things are there. Then they say finally they have set aside the order passed by the district court to place the custody of the child. Uh, uh, Even ignoring that the Muslim personal law mandates the male child above 7 years must be the custody of son. Here, paramount welfare of the child and child evidence was considered. Financial position of the mother was considered. So custody was granted to mother by setting aside the lower court order, and the father was allowed to visitation right. Go through the judgment, very interesting judgment. You can understand the judgment very well. Best wishes.